Welcome to ESGR Ombudsman Tips and Tricks ESGR. Case handling from assignment to closure. This training covers everything ESGR volunteers and ombudsmen need to get right. How you handle a service member's personal information, how you protect it and yourself online, and what to do when someone asks for records you're holding. Here's our roadmap for today. We'll start with the big picture, who actually owns ESGR, and where ESGR fits into that picture. Then we get practical. You'll receive a case, so we'll cover ICMS access and what to read first. From there, we follow the natural order of a case, talking to the service member, getting permission, talking to the employer, and working toward an agreement. The back half of the module covers the things that keep ombudsmen out of trouble. Confidentiality under ADRA, the 2, 7, and 14-day clocks, and the situations that don't fit the script, like a party who's not telling the truth to you, or an employer who wants you to review their handbook. Let's start with the big picture, and what that means for you specifically as an ombudsman. The Department of Labor is responsible for administering ESGR. DOL wrote the regulations, and DOL has the authority to investigate claims through its VETS arm. We don't. ESGR operates under a Memorandum of Understanding between DOL vets and the Department of War, and our operating instruction, ESGROI 1250.32, spells out exactly how we provide neutral, informal mediation. That's why we always tell the service member about their options. Work with us, request an investigation from DOL vets, or hire a private attorney. The choice belongs to the service member, and it needs to be an informed one. Now, let's look at working the case in ICMS. When the Ombudsman Director assigns you a case, your first stop is ICMS. The path is simple once you've done it twice. Go to esgr.mile, click Volunteers at the top of the page, then Resources, Library, then ESGR Portal. Accept the terms at the bottom of the page, enter your username and password, and tell the system how to send your two-step authentication code. Enter the code, and you're in. Make sure you bookmark the site so you can find it later. Nothing burns your 2-day clock faster than fighting a login screen. Find the case assigned to you and click Manage Case. Read the service member information, the employer information, and the case information before you pick up the phone. Case management is where you'll input everything you do, so get comfortable there. 2 things to check on that first read. First, is this a termination or lost wages case? If it is, your time frame is compressed. Second, did the service member give you enough contact information about the employer to actually work the case? If the employer information is thin, plan to fix that in your first call. If you can't get into ICEMS, tell your Ombudsman Director right away, don't sit on it, because your case clock keeps running. Click Forgot Password or contact your VST, and you'll get a temporary password. If you're still struggling, call the ESGR 800 number, and they'll walk you through a reset. The password rules are strict. 15 characters minimum with uppercase, lowercase numbers, and special characters, and at least 8 characters must be new compared to your old password. Spaces are allowed, but not at the start or end. No names, phone numbers, or dictionary words. Passwords expire every 60 days. You can't reuse your last 10, and you can only change it once a day. Here's a trick for inventing a long password every 60 days. Look at your keyboard. Start with the first 4 keys on the number row, hold Shift for the next 4, and build a pattern you can walk. You get length and complexity without writing anything down. From the service member's narrative, try to determine what the ESGR issue might be so you can study the parts of the regulations that apply. The quick reference guide is the best starting point. It lists issues by problem type and points you to the matching sections of both 20 CFR and 38 USC. From there, 20 CFR Part 1002 is searchable by keyword. A note on sources, 38 USC Chapter 43 is the law itself, and it isn't user-friendly. Rely on 20 CFR Part 1002 instead, since DOL wrote those regulations to implement the law and they read like plain instructions. You can use a search engine to locate a section, but only as a pointer back to the regulation or statute. Never rely on a third-party article for the answer. Then read. Refresh yourself on the relevant parts before you call anyone. And if the issue won't come into focus, call your OD or your mentor. That's what they're for. Strictly use the current OMBSC Interim AI guidance. Now that you have done all your research and made a plan from what you already have been given, let's start talking to the service member. Now you will call the service member within 2 business days. The contact with the service member doesn't need to result in a conversation. What matters is that you made the attempt on time. If you don't reach them on the first try, send an email the same day if one is provided, and try a text too. Different people answer different channels. Give it 4 full days of attempts across phone, text, and email. If you still haven't heard back, close the case in ICMS and note that the service member has not responded. Don't feel bad about it. The service member can open a new case when they're ready to engage. When speaking to the service member, open the same way every time. Identify yourself as a volunteer with ESGR, an office of the Department of War. Say that you're not an attorney or that you're not acting as one. Tell them you're a neutral mediator and you don't represent either side. Those 3 lines protect you and they set honest expectations for the service member. Then explain the choices. Work with ESGR, contact DOL vets for an investigation, or hire a private attorney. If the service member wants to proceed with ESGR, ask what issues prompted them to reach out and let them talk. Your job in this call is to understand their perspective, not to judge it. 2 guardrails while you listen. Don't try to interpret the law and never tell the service member the employer has violated it. Stay objective, take no sides, and make no commitments about how this ends. If the service member is in the National Guard, verify they're not on state active duty. Title 32 and Title 10 orders are protected service under USERRA, but state active duty is a state matter. Members of the National Guard serving on state active duty. A, for 14 days or more. B, in support of a national emergency declared by the President under the National Emergencies Act, or C, in support of a major disaster declared by the President under Section 401 of the Stafford Act, are now covered under USERRA. If duty is outside our lane, refer the service member to DOL vets, call your OD to advise them, and close the case. Ask whether they've hired an attorney or already opened a case with DOL vets. If either is true, tell the service member you can't proceed and close the case. And this rule has no exceptions. Never discuss the case with a service member's attorney. If one calls you, say you're not authorized to speak with them and refer them to the ESGR 800 number. If a friend or a service member's cousin provides legal advice, isn't the same as hiring a lawyer, call your OD if unsure. Ask the service member what resolution they want. The answer routes the whole case. Our mission is to repair the working relationship between the service member and the employer. If it's a termination case and the service member doesn't want the job back, there's nothing for us to mediate, and you close the case. That doesn't mean they lack a real USERRA claim. It means the right door is DOL vets or a private attorney, especially if back pay is what they're after. Some service members just want to teach the employer a lesson. Same answer. Before the call ends, tell the service member you won't share anything they don't want shared, and verify exactly what you may pass along. Then ask for permission to speak to the employer. That permission is the gate for everything that comes next. If you can't reach the service member, can you call the employer and ask them to have the service member call you back? No, never. You must have the service member's permission before any contact with the employer. And once you have it, document the date of that permission in ICMS case management. Sometimes the service member wants to approach the employer first or doesn't want you making contact at all. That's their right. Offer to send relevant USERRA information so they can go in armed with knowledge. Then explain that you'll need to close the case since you can't proceed without contacting the employer, and that they're welcome to open a new case if they want ombudsman services later. And every email you send to the service member, the employer, or anyone else connected to the case carries the ADRA notice at the end. Now that you have the information from the service member, let's move on to working with the employer. Contact the employer, the service member identified, or the one your research turned up. The 4-day rule applies here too. If you can't reach the employer after 4 days of attempts, close the case as no contact with ER, tell the service member why, and refer them to DOL vets or an attorney. When you do get through, the introduction mirrors the one you gave the service member. You're a volunteer with ESGR, an office of the Department of War, assigned to help resolve an issue with one of their employees. You're not an attorney or you're not acting as one. You're a neutral mediator, and you don't represent the service member. Add one more line for the employer. ESGR supports employers too. Your job is to clear up USERRA-related issues, not to decide who's right or wrong. That single sentence lowers the temperature of most first calls. Make sure you're talking to someone who knows the situation and can actually make a decision. If the person can't or won't discuss the issue, ask who can. When the employer has an HR department or a legal office, go there instead of a supervisor. They're far more likely to know USERRA. Here is a difference that surprises people. You must never speak with the service member's attorney, but you may speak with the employer's attorney. It's often productive since an attorney representing the employer usually understands the regulations and can move their client towards compliance faster than anyone else in the building. If the employer doesn't believe you're really with ESGR, don't argue. Go to the ESGR website, resources, library, and find the form titled Employees Consent for ER to discuss issues with the Ombudsman. Fill in the blanks, have the service member sign it, and either send it to the employer or have the service member deliver it. And if your best contact just won't engage, remind them gently and without a hint of threat that the service member can work through ESGR, contact DOL vets, or hire a private attorney. Describe the issue as the service member reported it using only the information you've been authorized to share. Then let the employer talk. Tell them the confidentiality street runs both ways. You won't share anything with the service member that the employer doesn't want shared, and you'll verify what you can carry back. If it's apparent the employer's actions don't line up with USERRA, resist the urge to say so in those words. Explain how you think those actions may be an issue, and offer to send excerpts from the law or the ESGR FAQs so they can judge their own compliance. Get a commitment for another call after they've had a chance to read. Source discipline matters here. Use only the ESGR website materials, the regulations at 20 CFR Part 1002, the statute at 38 USC Chapter 43, or for federal employees, 5 CFR Part 353. Never send third-party opinions or random articles from the internet. And when you discuss what the law means, you may share your understanding based on your experience, while making clear you can't interpret the law. Plenty of employers feel USERRA is skewed toward the service member, and honestly, it is don't dodge that. Explain the why. Our military is all volunteer, and slightly less than half of it works for civilian employers. If service members couldn't count on returning to their jobs, we couldn't keep an adequate force. Framed that way, most employers stop arguing with the law and start working the problem. Small employers are a different challenge. No HR department, no legal office, and often no idea USERRA exists. Explain in general terms what the law is, offer to send the FAQs from the ESGR website, and provide the link. Ask them to read it and call you back within your deadline so the conversation can continue. Never fill the gap with third-party articles. If the employer is unhappy about the service member's military schedule or the service member won't communicate that schedule, tell the employer they have the right to speak to the service member's commanding officer. Be clear about what that gets them. No commanding officer is obligated to change a schedule, but the employer has a right to voice concerns, and DODI 1205.12 paragraph 3.2 requires the military departments to cooperate with employers in verifying service. The instruction is on esgr.mil, or they can call the ESGR headquarters number, 1-800-336-4590. if the service member refuses to provide the commanding officer's contact information. Refer the employer to that same national ESGR number. Now the hard stop. If it looks like the service member may have exceeded 5 years of cumulative service, do not attempt to resolve the issue. Call your OD or the ESGR 800 number for advice. The 5-year rule has a long list of exceptions, and sorting them is not an ombudsman task. Use shuttle diplomacy. Carry each side's authorized positions back and forth, and work to understand what actions each party will take to resolve the issue. You're not writing a settlement agreement, you're getting two people who stop talking to start again. Here's the counterintuitive part. Once the service member and employer are talking and it's apparent a solution will be reached, close the case. Don't wait around to watch the agreement play out. Notify both parties you're closing it as resolved, and remind the service member that if the agreement falls through, they can open a new case. If the employer welcomes ongoing USERRA guidance, give them DOL vet's contact information. And when a case resolves well, suggest the service member consider nominating the employer for a Patriot Award. It costs nothing, and it turns a dispute into a relationship. ICMS gives you a short list of closure codes. Resolved means an agreement has been reached between the service member and the employer. Not resolved means it hasn't. The administrative closures cover everything else, other, for things like a case that turns out not to be a USERRA issue, no contact with service member, and no contact with employer for the 4-day rules, and administrative error for duplicates. If the parties can't agree, remind the service member that an investigation can be initiated with DOL vets by filing a Form 1010, or they can hire an attorney. Closing not resolved isn't failure, it's routing the case to the right next step. Then clean house, delete all emails, text messages, and voicemails about the case from your computer and phone, and destroy any paper notes. If you get a follow-up call later, the case is closed. They can open a new case or contact DOL vets. So now we will look at staying safe with the ADRA and the clock. Confidentiality and the ADRA. The Administrative Dispute Resolution Act bans neutrals from voluntarily disclosing dispute resolution communications along with anything provided to you in confidence. There are 4 statutory exceptions, and none of them apply to ombudsman work for ESGR in practice. Everything both parties tell you stays with you. Use the ADRA notice at the end of all emails you send to the service member or the employer. It isn't practical to include it in text messages, but treat those messages as equally confidential. And delete everything when the case is done. Who can you talk to? Your ombudsman mentor, your ombudsman director, or a national ESGR case manager, that's the list. You may call DOL vets to discuss the issues in your case, and they're an excellent resource, but never reveal the names of the service member or the employer. 3 numbers to memorize, 2 business days to make initial contact with the service member. The attempt counts even without a response, 7 business days to complete a case involving loss of wages, and the national case manager may grant an extension of up to 14 days. 14 business days for everything else, with extensions up to 30 business days possible, routed through your OD. Extensions are for one situation. Resolution is probable and imminent, but a party can't act right now, like a final decision maker who's out for a few days. If a decision maker is gone for a long stretch or the service member is about to deploy and can't participate, don't request an extension. Close the case and ask the service member to open a new one when both parties can engage. To request an extension, call your OD, who works it through the National Case Manager, and update ICMS every day you have activity, with a note at least every 3 days, no matter what. Let's walk through this with a real example, because the timeline rules make a lot more sense once you see them play out. Say a loss of wages case shows up in your queue on a Monday, the 2-day rule starts counting immediately, so you need to have made contact with the service member by Wednesday. There's no extension on that piece, you just have to make the call. The clock doesn't stop there. Since it's a loss of wages case, the 7-day rule kicks in too, which means you're either closing the case or asking for more time by the following Wednesday. Here's where a lot of people trip up. That extension request doesn't go to your ombudsman director. It goes to the National Case Manager. Your OD can help you get there, but the NCM is the one who actually signs off. 4 situations should have you calling your Ombudsman director the same day, not the next morning. First one, a loss of wages case that's creeping up on the 7-day limit. Get ahead of that before the clock runs out on you. Second, if a service member says anything that sounds like suicidal thinking, get them connected to a crisis counselor right away. You may call 866-578-7467. The first message is if you are in crisis, call 911 or go to a local emergency room. Talking to their trained counselors, they advise someone to call the Veterans Crisis Line 988, option 1. Third, if either the service member or the employer starts getting aggressive or making threats, tell your Ombudsman director immediately. And if you think someone's actually in danger, call local authorities too. Fourth, if you realize partway through a case that you personally know one of the people involved, that's not something you get to weigh on your own, it's an automatic reassignment. And one more thing while we're on documentation. Every note you write in ICMS should follow the same formula, an action verb, what actually happened, and something measurable like a date. 2 lines tops, no opinions, and never a name. Good notes protect you and protect the program. Before we move on, let's build out your bookmarks bar really quickly, because you're going to want these saved. ICMS, MMS, and Event Plus all sit under one portal, esgr.csd.disa.mil, so that's the one link you actually need. If you ever get stuck on something bigger than a password reset, HQ ESGR's customer service line is 1-800-336-4590, option 1, weekdays, 8 to 6 Eastern. If a service member ever says something that worries you, don't wait around. The Veterans Crisis Line is 988, press 1, or you can text 988 also. And for the actual legal text, keep 20 CFR Part 1002 and 38 USC Chapter 43 bookmarked. Small thing, saves you a scramble later. Bookmark 20 CFR Part 1002, 38 USC CH 43, and 5 CFR 353 from the ESGR website DOL Vets website or the actual ECFR website. Do not use 3 RD party websites, as that information may not be current. Now let's look at some tricky situations that you may encounter. If you know the service member or the employer is not telling the truth about the basic issues, you won't reach an agreement. Don't accuse anyone. Say you're not an investigator and can't determine all the facts, close the case as unresolved, and refer the service member to DOL Vets or an attorney. Documents are a trap. Don't accept any documentation from either party. Keep the mediation focused on the issue as the parties understand it. The same goes for employer handbooks and policies. Never agree to review them for compliance. That's attorney work. Conflicts of interest. If you discover you personally know a party, call your OD and report it. An ongoing personal relationship means you withdraw and the case gets reassigned. And when parties ask to meet you in person, ESGR policy does not authorize it. ESGR OI 1250.32 paragraph 11.5.4 rules out individual meetings for safety and neutrality reasons, and paragraph 11.5.5 lets a joint session happen only through the proper channel. Your OD engages a national case manager who can coordinate a telephone conference. You never initiate one yourself. Here's a pattern you'll see. A service member notifies the employer about a 1-year deployment and gets terminated on the way out the door. Advise the service member that USARA's reemployment protections become relevant once an attempt to return to work is made. On occasion, the real culprit is the employer's HR system, which simply has no category for military leave. The practical play is to recommend the service member open a new case when the deployment is complete and they're ready to seek reemployment. If the service member insists on pursuing the issue now, refer them to DOL Vets. Depending on the circumstances, USARA's anti-discrimination provisions may already be in play. And that's an investigator's call, not ours. Since January 2nd, 2025, the DOL Act's expanded protections apply to cases arising on or after that date. Let's put the bookshelf in order. 38. USC Chapter 43 is USERRA itself, the foundational law from 1994 that establishes employment and re-employment rights for service members. 20 CFR Part 1002 is the set of regulations DOL wrote to implement it, and it's the document you'll actually work from. 5. CFR Part 353 covers the same ground for federal employees, published by OPM. Titles 10 and 32 both count as protected service under USERRA. The difference is command under Title 10, National Guard members become a federal force under the President. Under Title 32, they stay under their governor with federal funding. What's not protected is state active duty, which is why you screen for it on the first call. 2 newer items round out the shelf: the Elizabeth Dole 21st Century Veterans Healthcare and Benefits Improvement Act, Public Law 118, 210, expanded USERRA's anti-discrimination and anti-retaliation protections for cases arising on or after January 2nd, 2025. And our own governing documents, ESGR 1250.32, which defines the Ombudsman Services Program, and DODI 1205.12, which establishes employment and re-employment rights policy across the Department of War. That's the module. You have the roadmap, the scripts, the clocks, and the bookshelf. When something doesn't fit any of them, you also have the most important resource in the program, your Ombudsman Director. One call, use it. Great, you have now learned about some tips and tricks to make you a better ombudsman. Now let's do a check on learning. So let me ask you this question. How many business days do you have to make initial contact with the service member? The answer is B, 2 business days. The attempt is what counts. It doesn't need to result in an actual conversation with the service member. What's the most extra time the National Case Manager can grant on a lost wages case? The answer is B, up to 14 more days. Lost wages cases run on the 7-day rule, and the NCM can add up to 14 additional business days if resolution is close. So now, whose permission do you need before you contact the employer? The answer to this question is 2. No permission from the service member means no contact with the employer ever. Once you get it, log the date in ICMS Case Management right away. So what if a service member mentions their cousin, who is a lawyer, and the cousin gave the service member some casual advice? Does that end the mediation? The answer to this would be 2. Retained representation is the trigger, not a family member's off-the-cuff opinion. You should not speak to any lawyer for the service member. Remember, only if the employer asks you to speak with a legal counsel for the employer is the only lawyer you should speak with. If you're genuinely unsure whether someone counts as retained counsel, call your OD. Which of these is something you can never do while mediating a case? Let's go with answer B. You can talk to the employer's attorney. That's often productive since they usually know the regulations already. The service member's attorney is the one line you never cross. Refer them to the ESGR 800 number instead. So what if a service member may have gone over 5 years of cumulative service? What do? Answer 3. The 5-year rule has a long list of exceptions, and sorting them out isn't something an ombudsman handles solo. Stop and call your OD or the ESGR 800 number for guidance. Now, a service member says something that sounds like suicidal thinking. What's your very first move? Answer C, safety comes first every time. Stay with them and get them connected to the Veterans Crisis Line right away, then loop in your OD. If you call 866.578.7467, the first message is, if you are in crisis, call 911 or go to a local emergency room. Talking to their trained counselors, they advise someone to call the Veterans Crisis Line 988 option 1. Now let's think of, what does closing a case as not resolved actually mean? Answer C. Not resolved isn't a failing grade. It just means the next step is DOL vets or a private attorney instead of ESGR mediation. Congratulations! So now that we have completed the training, let's take some questions that you may have. If you think of anything else in the future, let your OD know and reach out to the Ombudsman Services Subcommittee to provide your questions and improvements.